which is a telecom update of 2015, a look at federal, state, and local regulatory, legislative, and judicial developments. My name is Christy Marie Lopez. I'm your moderator for this morning. I currently work for a law firm called Alshire & Winder. We represent about 20 cities throughout the state of California, and I'm the one who handles all their telecom and cable issues. And I am pleased to present a very prestigious panel here for you today to discuss some of these issues. Seated immediately to my right is Javan Rad. He is the Chief Assistant City Attorney for the City of Pasadena and has been with Pasadena since 2005. Mr. Rad oversees the Civil Division and City Attorney's Office and also handles a variety of litigation and advisory matters in the areas of constitutional, tort, and telecommunications law. Mr. Rad is active in various capacities for the League of California Cities City Attorney's Department. He also currently serves as the president of the City Attorneys Association of Los Angeles County and is actually one of my fellow board of directors for SCAN-NTOA, as I also currently serve as the president for SCAN-NTOA. Mr. Rad graduated from Purdue University with a bachelor's degree in, get this, quantitative agricultural economics, and he also graduated from Pepperdine University School of Law. Now, all of the panelists did provide their bios using their first names, but for Javan, I had to say Mr. Rad as many times as I possibly could. So, now seated in the middle is Brian T. Grogan. He's a shareholder with the Minneapolis law firm of Moss and Barnett, practicing in the firm's communications, business law, and infrastructure practice groups. Since 1988, Mr. Grogan has worked with entities throughout the country on a variety of cable, telecom, wireless, and broadband communications issues. In his business law practice, Mr. Grogan focuses on fiber and conduit lease agreements and contract matters in the technology industry. Now, Mr. Wassenaar, at the very end, is the president of the Alliance for Community Media. And as many of us know, this is the organization which supports, promotes, and defends public educational and government access television in the United States. Mr. Wassenaar served 13 years as executive director of St. Paul Neighborhood Network, a community media center in St. Paul, Minneapolis. During that time, he worked as a lead partner in the Community Technology Empowerment Project, an American Corps program promoting digital literacy in the Twin Cities. Mr. Wassenaar has worked in community television and community and public radio for over 30 years in Minnesota and Wisconsin. So now, let's get started. I'm going to let Javan go ahead and kick it off, and he's going to address some of our wireless issues.
Okay, thanks, Christy. I'm going to kind of start out with a few just sort of examples of what's going on sort of around the country. You sort of see issues on wireless sort of popping up in different communities, but the reality is they're all kind of the same issues where, you know, residents have concerns, carriers want to come in and get service, and sort of how do things play out. So first off, let's see if I can, there we go. Fairbanks, Alaska. One of the neighbors that really wants the coverage, you know, they find out whether they need coverage by having potluck dinners, and so you got some people that are opposing it, some people having potluck dinners saying they talk about cell service, they can't get service. So that's up in Fairbanks, and over in Lehigh Valley, Pennsylvania, I guess Lower Macungie. Verizon comes in and says, hey, we'll give you $23,000 a year for a cell tower. That's rent to the city. And the city turns it down. You know, they just said, we don't want it. We don't want your money. So they turned it down. Obviously, you know, they've got their own issues. It's an opportunity for revenue, but obviously, you know, other issues at play, aesthetics. So that's going on in Pennsylvania, suburban Pennsylvania. The next one, couple of churches, actually. I actually just kind of like the headline here. Just one church gets a bell tower, another gets neighbors' complaints over the cell tower. So, again, the church has an opportunity for some revenue, but, you know, another church has, you know, some complaints from the neighbors. So, really just sort of you start seeing different issues, but again, sort of same folks coming into play. I want to show you what's going on. Pasadena a few years ago, we had some litigation, and T-Mobile wound up putting up a new antenna on top of an existing light pole. They actually swapped out the light pole, but if you can kind of see the projection of about 6 or 7 feet on top of the pole, that's the antenna, and it actually was blended really nicely with the rest of the pole. So it actually, personally, I thought it was a pretty good settlement agreement. We got it worked out. But I thought the article was kind of interesting in the sense that the headline didn't really match one of the quotes. And the headline says, "Tiny cell phone antenna has Pasadena residents on edge." And then the quote from one of the residents says, "I haven't noticed it. Is it just that thing on the top of the pole?" So, you can't win. So, anyways, Burbank, they actually recently, about 2 or 3 weeks ago, they just updated their wireless ordinance to incorporate 6409 rulemaking, and they hadn't updated their ordinance in a few years, so it's pretty comprehensive. And again, I wanted to share one of the quotes from Verizon rep. So she calls it an exceptional process, says she didn't support it, and then she says it would create a boondoggle for attorneys. So I can't figure out, where the carriers are on that. But Burbank's a couple towns away from Pasadena, about similar size, and so it's kind of interesting to see the different issues in play over there. So really, just there's a lot of characters that come to the table when cities either have larger proposals, doing ordinances, and so how does all that play out, sort of with the FCC and the courts. With the Telecom Act itself, I want to kind of go through this. This is sort of a 2015 update of sort of what's going on now, but I want to kind of give you a little history to kind of take you through where originally with the Telecom Act, one of the 5 limitations on local government was that cities need to decide the applications in a reasonable amount of time. That's all it said. So you could infer for smaller facilities, might take a short amount of time. For larger facilities might take a longer amount of time. But the reality is that just a reasonable amount of time, the words are what Congress said they are. And the FCC said they're not. So we get the shot clock ruling. And in 2008, the carriers petitioned for a declaratory ruling with the FCC. 2009, the FCC issues it, goes to court, goes to the Sixth Circuit, ultimately the Supreme Court in 2012. Supreme Court affirms, and you wind up with a couple of different shot clocks. You wind up with 90 days for co-located facilities, and that's basically once the city says, okay, your application's complete, then the clock runs. And for the 150 days, same thing. If the application's not yet complete, then the clock's not running. But the reality is that going back to sort of the Telecom Act itself, the city's having to decide the applications in a reasonable amount of time. Generally what that means is that if the carrier doesn't like how much time it's taking, they just go to court, and the judge doesn't say issue the permit. The judge just says, city, you need to hustle up and you better move on this. You better make a decision. But the judge won't say, city, you need to issue the permit. And so here, this followed that, so that the FCC said, we're not going to say you got to issue the permit. We're just going to say, if you don't meet these shot clock deadlines, there's a presumption of unreasonableness. That's all, nothing more. And so really in that sense, this is just sort of moving the ball a little forward with the FCC. So then we get to 2012. Section 6409A of the Middle Class Tax Relief Act. That's where things got a little interesting. And you're going to get an afternoon session from Steve Traylor. He's in the back there, so I'm not going to rain too much on his parade. But basically, if there's not a substantial change to the existing facilities and there's a minor modification, basically the cities must, they shall approve the permit. That's what 6409 says. There's a lot of terms like base station and substantial change that are not defined in the statute. About a year later, the FCC's Wireless Telecommunications Bureau comes out and says, okay, we're going to issue some guidance, but that's kind of out of thin air. It's just a bureau of the FCC. It's not rulemaking. It's not anything that Congress intended. And people are still kind of left out in the dark as to, what 6409 means with this sort of the definitions, the shall approve. How does it all sort of play out? So FCC then does a notice of proposed rulemaking. They take some comments. And NATOA and all the national groups and a lot of NATOA chapters, including SCAN, submitted comments in the rulemaking. But ultimately, the FCC issued the report and order saying you're basically going to approve the permits. Really tough statements from the FCC commissioners. There's one from Commissioner O'Reilly up here, and I'll read you a couple others. Another one was, too often, the process to obtain the necessary approvals can be both expensive and time-consuming. And this is sort of the perceptions, that we're getting from the FCC. And the next one is far too long and in far too many places, a web of regulations has entangled those trying to build infrastructure. Delays, needless paperwork, and moratoria all mean higher cost and accordingly less development. So if you read that, you're kind of feeling like that. So, not so good. Not so good. So this is where it leaves us. So basically, in short, the FCC did define base station. They defined what a substantial change is, but they basically just, did it themselves. They picked their own definition. They didn't really rely on anything that Congress did. They just said, hey, we'll just go ahead and define it. The other thing, though, is they treated the term shall approve to mean cities have to approve within 60 days of submittal. And so really what that is a deemed granted remedy. On day 61, the carrier can now come into a city, give a notice, and start building. This means that if you have to issue land use permits, you got to do it in the 60 days. If you have to issue building permits, you got to do it in the 60 days. If you have to have some kind of environmental review, you got to do that within the 60 days. This doesn't, once the application comes in under the 2009 shot clock, you actually could wait to deem it complete. Once it's complete, now you're kind of off and running. Here the trick is that you're off and running once that thing's submitted. So, boy, that's a lot different. And that's a game changer from what the 2009 shot clock was. And so really it is something that was really significant. The FCC did clarify the 2009 shot clock ruling, and one of the things that they did say was if you got moratoria, that's not going to stop the clock from ticking. And so you can sort of see if you're under the 90-day shot clock, 150-day shot clock, or a 60-day shot clock, if you've got a moratoria, you better be thinking about it on a staff level and bringing it back to your city council, town council, board of directors really soon. So the FCC's report and orders now in the U.S. Court of Appeals in Richmond, Virginia, and Montgomery County, and a number of cities have filed suit to challenge the report and order. PCIA and CTIA are also, they've intervened in the case, and so they're supporting the FCC in the proceeding as well. The short version of the arguments here is that the FCC really just picked the definitions out of thin air, and then the next thing is that 6409, by Congress saying that cities shall approve, what they're doing, what Congress is doing is they're basically commandeering local government, and that violates the 10th Amendment, and so that's the argument that's been set forth. There's actually a case out of San Francisco that's being litigated right now in the California Court of Appeal, but it actually addresses 6409, and San Francisco did lose that issue at the trial court level. One of the things that's problematic with that is, as cities, you can say, well, it says you shall approve, so we're left with no choice but to approve it. And what the response is, no, you can just wait for 60 days to go by and they'll just give you a notice and build on day 61. So you're not really compelled to grant a permit. You can just wait for them to start building. So it's a little illogical, but it's that's sort of the approach on how how the courts would view it if they took a position against the cities here. And the FCC is entitled to a fair amount of discretion, but hopefully we'll get a good ruling out of the Fourth Circuit here. Oral arguments set for the end of next month, and in the meantime, 6409 and the report and order, that all remains good law. So just kind of some takeaways on 6409 for the meantime. First thing is don't assume that that Congress and the FCC's taken things away from you. They've just crammed down the time you have to act. You still have your ability to exercise your local land use controls, and so think about what you can do within the shorter time frame. Sure, you're going to have to prioritize processing wireless facilities compared to other types of land use applications you might get, but really it's not out of your hands, and sometimes the easy thing to do is to say, well, Congress took it out of our hands, or the feds took it out of our hands, and that's not really true. They just said you need to move a little quicker. The next thing is that for purposes of deeming an application incomplete, the FCC said you got to have some level of submittal requirements as a local agency, and doesn't even have to be an ordinance. It could be your planning director, your public works director, your city engineer, your zoning administrator. Somebody just come up with a memo, come up with a list, so that when carriers come in, they have the list of things that they need to bring in. If you deem the application incomplete, you're stuck with that list. If you don't have a list, you can't really deem it incomplete, because one of the things is that if you don't have a list on what makes a complete application, you can basically deem anything incomplete if you want to. And so what the FCC said, it's only fair if you make the list, show it to the carriers, they have to comply with it, and then basically start slimming down the issues as to what gets to a completed application. And not a granted one, just a complete one that can be processed. The next thing is that with the really short time frames, if you have to have some level of public hearing, public meeting, or public notice, you send postcards to people that live within, 500 feet or something like that, get that out the door ASAP, because you're going to have to get that out the door, get it back, think about it, process it, and decide it all within these short time frames. Which shot clock applies? Does the 2009 shot clock apply? Is this a 6409 facility? Next thing is that as staff, what are you doing to really make sure that you can get this decided in a timely manner? If you have an idea that, we're going to spend hours and hours of review and thinking about this, can you really get it done and decide it within the time frames of whatever shot clock you're stuck with? Next thing is ordinances. Burbank just redid their ordinance a couple weeks ago. A number of cities are updating their ordinances in view of 6409. Sometimes with legislation, sort of when you're updating an ordinance like this, you could have language that says if 6409 is overturned, a lot of our ordinance goes away. So you can do something like that if you still want to move forward. The national leagues, including NATOA and then also CTI and PCIA, have a model ordinance that's available on their websites. That's one source of authority that you can use to crib from in terms of putting an ordinance together. A few other things to think about. The FCC in the 2014 rulemaking said if cities have a preference that carriers locate their facilities on municipal property, like that suburban Pennsylvania town that was, Verizon wanted to come in, they wanted to locate on city property. Is it bad if cities have sort of an easier application process for locating on city property? And the FCC said, no, that's basically just cities doing business and trying to make a buck, and at the end of the day, the carriers are also got an easier path to getting their application granted. So think about if you have some preferred sites that you might want to locate facilities on, and that might get things outside of neighborhoods that might not like the facilities. Next thing is you can still ask the carriers whether they have a gap in service, whether the gap is significant, what they're trying to achieve with their gap, how many customers they're trying to get, where they really need to locate things. Can two antennas that are in good locations do the job of one that's in a bad location? In terms of alternative sites. And then also really think about what your residents need, what your businesses in town need, if you have visitors that might come for special events, what they might need, and then also think about what the carriers need too, and not necessarily to accommodate them, but to just think about what they need and how that can perhaps be matched up with what your residents need. So one of the other things that the Telecom Act requires is that when cities decide wireless facility applications, they have to decide them in writing. And, what does in writing mean? In the past, we might have thought it just meant, it's denied, the application's denied. But now the Supreme Court has said it means a little more than that. The picture over here to the right is Teddy Roosevelt's mother's house in Roswell, Georgia. So, for anybody from Georgia here, so. That's the connection. There's no antenna there, by the way. With T-Mobile, they had an application with Roswell. Application was denied. Come back at like the next city council meeting, something like that. They approved the minutes from the last meeting, but there's a 26-day gap between a letter saying your application's denied and then the minutes that actually describe what happened at the meeting. And so you've got a 26-day gap there. 11th Circuit actually ruled for Roswell and said, the letter saying your application's denied, that's close enough and that meets the in writing. T-Mobile, you should be off and running. Supreme Court said, no, you gotta put reasons in your denial. So in writing means put reasons for your denial. And one of the things, so they said, they don't have to be anything big, you don't have to be any kind of a great writer or anything like that, but you have to allow the court to understand what's the real issue if the carrier were to bring the issue to court. What the Supreme Court did say, though, was that Roswell's practice of sending a letter saying your application was denied and separately shipping the minutes out, that's fine. So that's something, that as a city you can still do, but the thing is that those two documents should travel, about the same time. And so essentially contemporaneously. So 26 days, that's not really going to cut the mustard. There's actually two cases that have addressed the Roswell decision since it came down in January. And one of them was out of a trial court in Florida, in federal court. And the two blurbs at the bottom, those are actually, nicely detailed, and I think, you can tell they're written by a planner in terms of the specificity of, hey, you didn't meet the requirements. And the court had no trouble saying, you know what, it's a low hurdle, that meets the in-writing requirement. And then next case is out of Court of Appeals, 8th Circuit in Arkansas. And so here, there was a 24-day gap between the denial letter and the reasons for denial, and the court said, yeah, that fails the Roswell case. But they said, it doesn't matter, it's what's called harmless error. So they pulled that term from a concurring opinion from Justice Alito in the Roswell case. He said, look, in the Roswell case, T-Mobile was at the meeting when everything was discussed. They knew what was discussed. So when they got the minutes later, that may have, started their time to actually bring suit. But, nobody's really hurt out of this. T-Mobile actually, in the Roswell case, they paid for a transcription of the meeting. They knew it was there. They didn't need minutes to figure out the reasons for their denial. And so here, ultimately, the court said, no harm, 24 days off, yeah, you failed the Roswell case, but no harm, no foul. So we're in San Diego, so we got to have the chicken and got to have a San Diego case. But this is actually the really good case out of the Ninth Circuit, but I think it's something for folks around the country. Just for the concept of a lot of times when you have carriers that come in, they say, we can't get coverage, we have a gap. And then you ask the question, well, what can you tell me more about it? And they say, no, that's confidential, that's proprietary. We can't tell you. And so San Diego said, okay, well, we'll just deny it because you're not giving us any information. And so American Tower sued, and the court said, no, if you're not going to share the information, that's not fair play. And so cities don't have to just accept the carrier's word. If the carrier says we've got a gap, then you actually can ask them, hey, so tell us about it. Let's see the information. So I think that's a really helpful decision. So just kind of on state legislation end, you've got 96, Congress says you got to decide an application in a reasonable amount of time. 2009, the shot clock ruling comes in, 90 and 150 days. Okay, things are getting crammed down a little bit. And then 6409 ruling, okay, things are getting crammed down a little more. So California, what's going on right now is there's a bill that would basically codify the 2009 shot clock ruling and convert that from just presumptions into a deemed granted. So basically no more, no more carriers have to go to court. They can just give notices if you blow the 90 and 150 days. That's huge, that's different, and that's going on right now in California. This, about 2 weeks ago, the bill passed through the state assembly, and it's actually been sitting on the governor's desk since last Thursday. So it's not a good bill. It's a real concern, and it really, with 6409, you think, okay, well, this doesn't apply to towers that are just coming in freestanding by themselves, no big deal. But basically, everything that's wrong with 6409 is now going to be applied to towers and just new things that are coming in. So it's really significant, and it's really bad news in California. But it's also a fairly short piece of legislation that somebody can copy and paste and travel elsewhere. So if you're in California, and have access to the governor's office, I encourage you to write the governor. If you're outside of California, this could come to you. So I think be aware of this. So really the couple things to kind of keep in mind for the year going forward. 6409 ruling, what's going to happen in the courts on that? We may not get a final resolution in the next year, but at least we'll kind of get some direction from at least the Fourth Circuit, see where things go. And then, like I said, with AB 57 in California, I think that's something that converting the 2009 shot clock ruling to sort of deemed granted, where you're out of luck at 90 and 150 days. I think that would be, I'd be concerned about that in other states. So with that, I turn it back over to Christy.
Awesome. Thank you, Javan. That was a great presentation. I know that 6409 has been a very big issue for many of my client cities, and the first one that came in involved an increase in 18 feet, and it was very difficult to get the city attorney to swallow this proposal, and I'm hoping that maybe we can have some more discussion about that during our question and answer process, as well as, kind of maybe amending applications and not just the ordinances in terms of reflecting 6409, but again, I hope maybe our question and answer session. Also loved the San Diego chicken. I happen to have an autographed photo of the San Diego chicken from 1985. So with that, I'm going to go ahead and turn it over to Brian Grogan, who's going to kick it off on the cable side.
Thank you. My job today is to talk about the federal updates on cable television. Can everybody hear me okay? With a focus on the FCC. There we go. First, I'd just like to comment, Mike Watson never gave me a heads up that he was going to show a video about Eminem. That's not fair, because I could have brought a Prince video, I could have brought a Bob Dylan video. We've got plenty of artists in Minnesota that can rival Eminem, although that was a very cool song. And I'm going to apologize right away to my friends in Washington State for my very first slide. It's going to bring back some tough memories, but...
You should probably apologize to the Massachusetts
yeah,
as well. You need to apologize for a lot of people.
I got to apologize to a lot of people here. So we're gonna go with a sports motif today.
Obviously, there's a Vikings fan who put this.
Yes, well, of course. We'll get to the Vikings later, which, by the way, have never won a Super Bowl in the history of the organization. So right about the time that the Patriots were snatching a Super Bowl win away, and I'm not going to talk about Deflategate at all, but the FCC was snatching away a little bit of our LFA authority. And this occurred with the adoption of another of the 621 orders. We've had 3 of them now. This most recent one was adopted in January of 2015. And it did a number of different things. It followed up on the orders that came out starting in 2007. First thing it did is it said that, once again, it emphasized this only applies to local franchising decision-making authority, not to state-level decisions. So states like California, Texas, Wisconsin, Iowa, and you name it, there's 23, I believe, states out there that have state-level franchising. Nothing in this order really applies to you, particularly as it relates to some of the interpretations regarding franchise fees, PEG fees, and other issues, which is ironic in that you can cross a state line and have an FCC interpretation apply in one state but not in another, simply because what your legislature decided to do with franchising. I'm not sure I'm aware of another FCC order that kind of bifurcates the rules in this manner. But it emphasizes this order that, again, it only applies to local decision making. And I'm kind of toggling between 2 different things here, because what I see on my screen is different than what you guys are seeing here. They're controlling it back there for us. So in-kind payments is another issue they addressed. And really what we're talking about here is the things that you contract with cable operators for to go in your local franchise. Beyond franchise fees, beyond PEG fees, those things are generally considered in-kind contributions or in-kind payments. And the FCC spoke directly to that issue to decide whether or not those should be included when you calculate franchise fees. This is a direct quote from the order. Non-incidental in-kind fees must count towards the 5% franchise fee cap and does not limit the franchise fee exception to in-kind payments that are unrelated to cable service. What does that all mean? And in fact, we have to go back a little bit into the Cable Act, and we know that the Cable Act says that you can require charges incidental to the award of a franchise, and those are in fact exempt from the 5% franchise fee. So what those are includes the following: payment of bonds, security funds, letters of credit, insurance, indemnification, penalties, liquidated damages, and in this case the FCC said other minor expenses. Just want to keep in mind here so everybody can do the math on this. If you're a jurisdiction that obtains $1 million a year in franchise fee payments for the company's use of the right-of-way, these things you can impose in your franchise over and above that. The next list I'm going to give you are things that potentially an operator could argue they're now going to offset or deduct from franchise fees. This is a change, significant game change, if you will, for how we calculate these issues when we're drafting a franchise. So the FCC held that incidental does not include consultant fees, attorney's fees, application fees that exceed reasonable costs, acceptance fees, free and discounted services, leased LFA equipment above market rates. Let's pause for a moment on free and discounted services. For the better part of 40 years, cable operators have been providing free cable service to schools and public buildings, right? Basic expanded service. It was initially provided so that you could monitor those channels, so that you could be better prepared when customers called and complained. You could turn on the television set at City Hall, you could help them troubleshoot, and only if necessary would you follow up with the cable operator to try to get the consumer complaint solved. They also threw in free service drops to police stations, fire stations, etc. And frankly, many of those bought up. If they wanted to buy HBO, the policemen and firefighters pooled their resources and bought up beyond just the limited basic and expanded that they received. This order calls that all into question. And those of you who have been in franchise renewal recently know that this issue is something that now you're having to argue about where you didn't have to in the last franchise renewal. But it doesn't come up just in renewal. It technically comes up in every single local franchise that you have out there. If you have a commitment that says cable operators shall provide free cable service to schools and public buildings, you have 100 locations where you have those free drops. There's a value to that, whatever that value may be. There's a potential that a cable operator could come back and say, because of this order, I now have to offset this against your franchise fees. So I'm going to take $100,000 off of that $1 million franchise fee payment, and I'm just going to deduct it or offset it. Now, there's a lot of argument about this order. I'm simply stating for you what the FCC order provides. I'm not suggesting that the operator necessarily has that legal right, but we're certainly hearing it loud and clear from the industry in more recent negotiations. The other thing that this order did is it spoke to mixed-use networks. I'm going to kind of cut to the chase on this and say that if you're trying to use your cable franchise as a vehicle to regulate broadband or telecommunication services, the FCC says that's a no-no. You are not to go ahead and attempt to limit or restrict a cable operator's provision of non-cable services in a Title VI cable franchise. And they attempted to reiterate what they said in 2007 about that issue. So we're moving into the March time period. That all occurred in January. In March, we had Wisconsin, where I had 2 daughters graduate, battle the University of Kentucky in what was a huge upset in the March Madness basketball tournament. It was right about that time that the FCC also started its own battle, and that is they moved forward with their implementation of the Open Internet Order. And this is the one set of slides I'm going to talk about related to broadband services. This was a pretty significant order. It's happened in March of 2015. And it comes on the heels of the 2010 FCC order that was appealed, I'm going to talk about in a moment, and this is the FCC's second try at the issue. It was almost immediately appealed by everybody in the whole world. And I've just listed a handful of those who have appealed it. You notice several big names here among the list. Nobody seemed happy with it, which may suggest it was actually a well-reasoned order. But the order itself was really, as I mentioned, came on the heels of a defeat that the FCC took when they tried to implement their 2010 order on net neutrality. And that was struck down by the Verizon court. But the Verizon court gave the FCC a window when they said that broadband providers do represent a threat to internet openness, and they could act in ways that would ultimately inhibit the speed and extent of future broadband deployment. So this new FCC order addressed 3 key issues, the first of which was no blocking. So it starts by saying basically a person engaged in the provision of broadband internet access service shall not block lawful content, applications, services, non-harmful devices, It's always, of course, subject to reasonable network management. But the punchline of this is that consumers are supposed to get what they pay for, which is access to all lawful destinations on the internet. That's point number one, is no blocking. Point two, no throttling. You are not to throttle the services. So a person, again, engaged in the provision of broadband shall not impair, degrade unlawful internet traffic on the basis of this criteria. It basically creates a whole separate rule that you cannot degrade certain targeted websites that would otherwise be available for the customer's broadband connection. Finally, the third key issue that it addressed was no paid prioritization. So basically no fast lanes. And just to make sure we're all on the same page, paid prioritization in the FCC's world means the management of a broadband provider's network to directly or indirectly favor some traffic over other traffic. So you can't do any of these things. You cannot traffic shape, prioritize, you can't do a resource reservation, you can't do any kind of preferential traffic management, either in exchange for cash or money from a third party, or to benefit an affiliated entity, which is another key issue of this and relates to some of the comments that our earlier panel today talked about with respect to a closed network and what a cable operator may or may not be able to do on their over-the-top services in light of this FCC order. So we're still in March. The FCC had a busy meeting in March. So a lot of you know that Duke won the national championship, right? They won March Madness. North Carolina also won. And nobody knew that that happened. Why did North Carolina win? Because in March, the FCC adopted an order that preempted Tennessee and North Carolina's municipal broadband restrictions. An issue that many of you, many in this room fought long and hard over. It was the one, I think, really telling victory that we saw in 2015 for local government authorities. And basically, the FCC concluded that Tennessee and North Carolina state laws were barriers to broadband infrastructure investment and essentially were thwarting competition. So a victory there. All of these, you'll note, are 3-2 votes. These are very close issues that the FCC is considering. But nevertheless, a win is a win, and we're all pleased about that. So now we're moving into, we've gone through the spring and we're into the summer. And for us Minnesota folks, we're getting tired of the Blackhawks winning another Stanley Cup championship. They seem to win one every year. But they won one, and we're also getting a little tired of the cable industry winning every single time at the FCC. But that's in fact what occurred. And this time it was the effective competition order. So on June 3rd, the effective competition order came out, and I think Steve Traylor sent out an email to many of us today indicating that in fact it goes into effect today. Finally becomes effective. This is an order that essentially concludes that all cable operators are now subject to effective competition. So let's step back for a minute. It used to be for the last 20 years that if you wanted to get effective competition, as a cable operator, you had to go in and petition the city, and you had to prove that at least 15% of the population subscribed to a wireless cable operator, DirecTV, Dish Network, or you had to prove that there was a second cable operator, wired operator in town. If you could prove that, then you were deemed subject to effective competition. The city then lost all rate regulation authority. This order now shifts that burden entirely and says cable operators are deemed subject to competition nationwide. And if the city wants to fight that, now you have the burden to go in and prove that they have less than 15% penetration. Shifting the burden is a significant issue because it's very expensive to go out and get this data and prove up this case. So this is really quite a game changer when one considers how this law used to be implemented. As I mentioned, it's the first update in 20 years. The FCC reasoned in making this decision that they wanted to reflect the new multi-channel video programming marketplace. They wanted to reduce regulatory burdens on all cable operators. In fact, they were really only charged with trying to assess the regulatory burden on small cable operators. And they wanted to more effectively allocate FCC resources. That one I actually understand because I've had cases that have been pending for 6 years at the FCC on effective competition rulings, and I think I see a lot of heads nodding. That was a fairly common situation where we would see these things languish at the FCC. So I'm sure it will reduce their regulatory burden. This was challenged just recently on August 31st by the National Association of Broadcasters. NATOA also is participating in the challenge, and one of my clients, Northern Dakota County Cable Communications Commission, I'm supposed to emphasize for Jody Miller that this is Northern Dakota County, not North Dakota. So she's in Minnesota in a county of the Twin Cities. The NAB is concerned about this because they're worried that their channels, their broadcast channels, may no longer be carried on the basic service tier. They negotiate with the ability to always threaten mandatory carriage and retransmission consent. And if these rate regulations go away, so too goes away a lot of the authority that these companies had. NATOA has argued that the order will result in higher consumer prices and that it would potentially result in the removal of PEG from local broadcast, the local basic service tier, which of course would be a devastating impact for LFAs. So, moving forward, as we look out now to the fall and to the end of the year, will the Vikings win the Super Bowl? No. Come on, we had 4 good tries at it in the 70s. Will the FCC hand the LFAs a win? And I would say neither of those seems very likely. I've been a lifelong...
So you need to change your allegiances so we can get a win. Right?
Yeah. I've been a lifelong fan of the Vikings, and I am as optimistic as I try to be. I do not think that's a scenario we can look forward to. I also am a little concerned about the pending proceeding at the FCC, and this is what I'm going to conclude with. It's the multi-channel video programming distributor proceeding. You heard a lot about this discussed in the last panel, where I thought they did an excellent job of covering it. Just look at the title of it. It's in Ray, Franchising, Innovation, and Competition in the Provision of Multi-Channel Video Programming Distributing Services. It almost rings like this is for the good of mankind, this proceeding. And so you know that these decisions have largely been potentially made, and we're hoping that those proceeding, and I know I'm to put in a plug for, first of all, thanking all those who have participated in the proceeding. It's an expensive process, and all of us appreciate that. And certainly there's still opportunity for all of us to continue to participate. I think somebody mentioned in the hallway, perhaps even participating in coalitions that can join resources. Maybe all you can throw in is $5,000 to an effort. But if 10 cities do that, that can be a substantial pool of resources to try to move the issues forward. So as we look at this proceeding, it's really 2 different issues. There's a lot in here, but the 2 that I'm focused on. First, the FCC confirmed what we had hoped, which is that a managed linear IP video service, which I'm going to call plain old cable television service that we know and love, they tentatively have determined that it is a cable service under the Cable Act and will continue to be regulated. This is the kind where an entity, a cable operator, crosses your right-of-way with a closed transmission path, that they believe that is a cable service. And that's good, because if they had concluded that wasn't a cable service, then there's no reason to have a Cable Act anymore for all practical purposes. But that would be a cable operator of a cable system. LFAs would continue to have regulatory authority. The more troubling aspect of this is the over-the-top video programming, where the FCC tentatively concluded that a cable operator's OTT video programming is not a cable service. Again, as the earlier panel noted with some concern, if that's the case, if Comcast's service in Seattle or in Chicago, where they're presently rolling out their OTT, if that's not a cable service product, that means you don't get franchise fees on it. You can't mandate PEG channels. You don't get PEG fees. It has a very dramatic impact down the road. Now today, Comcast is in fact treating that in those areas where they hold a local franchise as a Title VI service, and they are in fact remitting the franchise fees, and they're carrying PEG channels to their credit, and I think we're all appreciative of that. That's exactly what we would hope they do. How it plays out, though, when the FCC order comes out on the MVPD distribution services, that may be a different issue. If they conclude, as they have tentatively concluded here, that that is not a cable service, one could expect that all of the operators will be reassessing how they classify this, and we're all going to have to pay careful attention to this ruling, make sure we listen to NATOA's leadership on how we can influence the outcome. So with that, here's hoping for a miracle, both for the Vikings and for the local franchising authorities at the FCC. But thanks very much, and I'll turn it over to Mike.
Thank you. That was very informative, I think, both on the cable and broadband side, as well as on the sports side, both collegiate and professional. So we appreciate that, and I'll go ahead and have Mike jump in. He's going to give us a real-world taste of everything we've been talking about.
Well, and the only thing I want to do, too, is just kind of buttress something that Brian was talking about, and that really is the need to invest in policy work and advocacy for citizens and community members. And really in 3 of the cases that you're talking about, it's a relatively small amount of effort that's having an impact on behalf of communities across the country. Just to reiterate something he just said, that with the MVPD rulemaking procedure that's happening right now, there's still time for participation and your participation. If you're interested in doing that, I'm happy to talk with you after the fact. Both NATOA members and ACM members actually have been involved in trying to push that forward, push their perspectives forward, and make sure that the FCC hears the perspectives of citizens, community members, local governments. So I really want to encourage you to be involved in that proceeding, and then also be thinking about investment in those types of cases, like the one that NATOA is doing right now. As president of ACM, I really want to applaud NATOA for taking a step forward in that proceeding. It means a great deal for my members across the country and for all of our communities. And then I also really want to applaud the actors who are working in the 621 case, which is being argued in court right now, if I'm correct. Some NATOA members actually have stepped up on that. So again, if there's one sort of broad message I want to have for everybody, is to please think about investing in advocacy for your communities if you think that the work that you're doing is worthwhile. And I would certainly hope that you believe it's worthwhile. Yes? Some hands? Yes? I've got 5 slides, and then I want to get to some questions from the rest of you. The only other thing I would say to Javan's case is a shot clock is a very interesting thing when you deal with the FCC. I am now in day 2436 of the ACM petition regarding AT&T's UVerse product. So I'm waiting. Perhaps I'm waiting like for a Viking Super Bowl victory, but we should have a big shot clock, if we will, here. 2436. It's nice when there are rules for thee, but not for me. That's all I need to say there from a I think Dr. Seuss probably has something to do with that. All right. So I've got 5 slides for you. Really wanted to supplement some of the work that Brian is talking about in terms of impact with PEG, Public Educational and Government Access. Really talk a little bit about some congressional developments over the course of the last year. And then one FCC development that you might have heard about that I want to talk about, and that is, but I'll get to that in the last slide. So in January, right around the time that Brian's infamous slide occurs in terms of this awful thing that happened to Seattle, some of us are still Seahawks fans as well. The House Energy and Commerce Committee issued a white paper number 6, actually it was in December, calling for comments on the regulation of the market for video content and distribution. It seems like a relatively mild question the series of questions that they raised about changes in the marketplace. This is part of the Telecom rewrite process discussions that the House Energy and Commerce leadership has had over the course of the last 2.5 years now. That's why it's white paper number 6. If you want to go to the questions themselves, it's available at the House Energy and Commerce website. The House asked a relatively innocent question. And just keep in mind that it is relative. We'll see if we can get to it here. The question is, and sorry for the scansion here, cable systems are required to provide access to their distribution platform in a variety of ways, including program access, least access channels, and PEG channels. Are these provisions warranted in the era of the internet? Question mark? So it seems like a relatively innocent question that just sort of got in the white paper somehow. Who knows how? These things pop up. Innocently enough, it came forward. Over 220 respondents came forward to the white paper. That's the largest number of response for industry communities for the House Energy and Commerce process over the course of the last 2.5 years. More public input to the committee leadership than on any single discussion as they've been talking about rewriting the Telecom Act. So that's because close to 180 entities, both PEG operations as well as local franchising authorities and their allies, spoke up. And it was because of the joint effort of ACM and NATOA and individuals and coalitions across the country that did so. And to be clear, your voices were heard. Actually, I don't have this on the slide. In talking with the House Energy and Commerce Committee leadership, they're really not interested in kind of flipping over the rock and fiddling around with you right now because of that. So that was great, but that was January 2015. You need to maintain activity and maintain consistent presence. It can't just be in a time of crisis that you come forward and have your voice heard. They do have some continuing interests in some aspects of legislation that could affect PEG, and that gets to the next slide, and that's in the U.S. Senate, where the reintroduction of the Community Access Preservation Act occurred in May of this year. Senator Tammy Baldwin has been the leader of that act. It's co-sponsored by Senator Edward Markey of Massachusetts. It's Senate Bill 1244. I'm not going to go into the long history of the CAP Act, which originally got its start in the House under then Representative Baldwin's leadership, but it was very much a product of the experiences of local franchises in Wisconsin that were affected by state franchising that came into play in 2006 and 2007 in that state. So it maintains the goals of the Act, which were first introduced in the House in 2008, but then it added provisions mandating high-definition coverage and electronic program guide insertion, which are, I think, laudable goals, and NATOA, ACM, and a host of other organizations are in support of the CAP Act's principles. I think significantly, there's no Republican support and no new sponsorship for this vehicle, despite numerous attempts to court support. Why is that? Well, you may have noticed that Congress does very little these days, if anything. Part of the question that comes up, at least from sympathetic Democratic ears, is the vehicle tenable? Is there a path to success? How exactly do you come up with a path to success? And in the current House and Senate, you need to have Republican support for anything to be able to move forward. There is considerable concern amongst the Republican Party around federal preemption issues of state laws that are articulated in the bill, and have been so since it was first introduced in 2008. There is some bipartisan support and interest in the capital operating definition change for PEG grants. That is one of the key provisions of the Act, primarily because that is a waiver of federal definition. It's the federal government getting out of the way of localism, which actually is something that Republicans believe in on a ideological level. And so there is some interest in that aspect of this. And actually you saw bipartisan support of the issue here in California this last year with the passage of AJR 39, which is being led by Assemblymember Roger Hernandez, who is from West Covina, I think, if I remember correctly, in the San Gabriel Valley, who wondered why he was paying PEG fees for great service when he's in Sacramento. You got great, amazing PEG services in Sacramento, and then he's paying the same fee in West Covina, and there's like diddly poo, to use the Jim Mora expression, since we're going to continue with the football metaphors here.
I'd just like the record to note he used that phrase, not me.
You know, there's a funny Harry Truman joke that involves manure, but he didn't use the word manure, so we'll talk about that later. So that was a bipartisan joint resolution from the California Assembly that passed this last year, which basically recommends that Congress change that one sentence in the Cable Act, specifically to get rid of that definition, to be able to enhance localism, to enhance civic participation, to enhance open government operations, and to actually have a flourishing of jobs in the local sector. And this is actually an area that I know that Assemblymember Hernandez will be continuing to push with the delegation in California. And actually, Senator Dianne Feinstein has expressed some interest in this issue, specifically short of the entire CAP Act, just because of the federal preemption issues, which are just deemed to be like non-starters in the current regulatory climate in Congress. So one other thing, one of the next slide I just want to have, and then kind of put it back to you, Christy, is one other FCC consideration that's happening for PEG. Later this year, the FCC Disability Rights Office plans to be holding a closed captioning and PEG workshop that's going to be happening on November 10th. If you don't have it in your calendars already, you probably should. It will be from 1 to 5 p.m. Eastern Time, so hopefully our friends in Hawaii will be able to participate via the FCC's website. This is an initiative of the FCC's Disability Rights Office that's being supported in consultation with both NATOA and ACM. And I want to reassure people that this is not a new set of discussions that's happening. There's been sort of a long brewing set of discussions, I know, particularly amongst NATOA members, in terms of what are the rights and responsibilities, the obligations, but then also the true costs of captioning for PEG coverage, either of live meeting coverage or of other forms of media distribution that's happening. And the FCC and the Justice Department are interested in these issues because of the concerns regarding increasing program accessibility to all Americans. That's the concern. So this is really sort of separate from the current FCC rules and really sort of questions about application of a number of other regulations that go beyond the FCC's ken to enforcement of a number of acts that the Justice Department has jurisdiction over, like the ADA. So this is really also reflects the sensitivity that our organizations have really to trying to reflect increased accessibility for all the citizens that we're serving, but then also, really frankly, to try to instill some reality in terms of what PEG operations can and can't do on the ground. One of the things I think is very, very important for people to realize is that not everybody knows that even though you run a TV channel, you don't have a bajillion people doing that work. And for many of our communities across the country, it's a 1 or 2 person operations. And they're very much sort of bootstrapped in terms of the amount of money that they actually have to spend to be able to do programming output. That is not a reality that decision makers at the FCC necessarily know. So this is actually an opportunity for us to be able to tell that story in some detail, to be able to talk about not just the rules that exist for our industry, but also reasons why people should be increasing accessibility, but then also be talking about affordable options, and to be talking about funding possibilities so that we can actually be serving all Americans with our services. And it's curious, on both the ACM listservs and the NATOA listservs, I've seen some trepidation about this workshop because of the possibility of new regulations being promulgated. That will not be happening. That will not be happening. This is really about the current obligations that we all have right now in terms of what, and the exemptions that exist for our operations as well, depending upon size and capability and economic impact that you may or may not have to be able to do captioning, but then also to be promoting ways in which our operations can be actually increasing the use. Not just for people who have disabilities, but also other populations that have need of captioning. People who maybe like British TV shows and can't understand the accents. Rick got that joke. But actually, more importantly, people who are looking for text assistance to be able to understand English and understand content better. So actually, that's an increasing amount of our population. And actually, as you're looking at the aging of America, and we are in the hard rock, right? Right? So if you played a Fender in high school, you may have noticed some ringing in your ears right now. The statistics are actually pretty incredible in terms of the aging population that will be needing captioning assistance over the course of the next 20 years. So this is really a question of our impact in our communities and our ability to be able to serve people well. So keep an eye on that. Please participate in that. If you're in the DC area, it's an open meeting. You're welcome to attend, but please go online to the FCC's website to take advantage of that. And with that, I'll kind of turn it over to you, Christy.
Awesome. Thank you, Javan. Thank you, Christy. 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 Thank you Can you hear me? Okay. So at this point, we'd like to open it up for some questions from the group. If you could raise your hand, I will start where I can. If you could introduce yourself by name and who you're with.
Hi, I'm Wendy Cretion with the South Washington County Telecommunications Commission. There was reference a couple of times to rewrite of the Telecom Act. When could we expect something to happen along those lines?
I think there's one level of theory that we will be seeing de facto rewrite happening piece by piece with little bits of legislation along the way, but I would not lay money on a congressional rewrite within the next 18 months, just because of the way in which Congress is working. Another alternate theory says that the work of the House Energy and Commerce Committee is really teeing up what could be a rewrite that occurs under the next presidency with a new Congress.
I would say, all likelihood, you're not going to see it in 16, but it'll be teed up and ready to go for, depending upon how the election turns out. That will be a linchpin in terms of which direction we see it heading.
And that's an election not just for the presidency, but also for Congress.
Right.
Right.
First a compliment, then a question. Tom Garrison from Egan Television in Minnesota. Compliment to Mike and ACM in the Comcast proceeding for making it very easy, even for non-ACM members, to know how to contact, who additionally to copy. It was very, very helpful, the template you put out, and maybe a model to move from. My question for the panel, based on the earlier session, that this is a long-term process that we're involved in, and I'm wondering what your ideas would be about what we should be doing beginning now and what will take a longer term. But what are some of the strategies that maybe we haven't implemented or found a way to come around collectively that you would recommend?
Yes, on the wireless front, I think, you see the Telecom Act sections pertaining to wireless, other than 6409, were last touched in 96. It's been 19 years. The industry is going to the FCC. They went to the FCC in 08. They got what they wanted in 09. They went to the FCC in 12 or 13. They got what they wanted in 2014. That's where the action is on wireless. I think one of the things sometimes as local governments that we struggle with is we all want to tell our story, and everybody's story is different, and that's what makes local government unique. The Telecom Act allows local governments the opportunity to be unique, but the problem for, I think, the FCC, when they're getting comments, they don't know how to, when they get 200 comments, they don't know how to put them together. And I think the industry can unify its voice better that says, cities are bad, let's give you examples and give us what we ask for. And I think it's just a cleaner way of doing it, but I think as local governments, we just need to be able to tell a cleaner story from a wireless front, but I think the action is more in the FCC than with Congress.
I guess I would comment that I've been doing it for 25 years, and the very first NATOA conference I came to, they said the sky was falling, and it was a nice run. We laughed, we cried, but it's over. And I thought, well, this is great. It's just starting my legal career. This will be a fun business to get into. And here we are 25 years later, and I guess the point I want to make is every time I talk to an elected official or to an executive in charge of the budget, they say, well, Brian, you told me that last year. You said the same thing 2 years ago, and we did go ahead and put up resources, and we participated in a coalition effort to try to file comments. I guess I would say it's an education process to explain that it's going to be an every year process. This is, it's death by 1,000 cuts, if you will. So Mike Watts, I thought, made a nice comment earlier talking about trying to get into the mindset, a percentage of what you obtain. If you happen to be a community that makes $1 million on franchise fees, maybe you want to start advocating that a percentage of that, whatever it may be dedicated to a war chest, if you will, to take on certain proceedings where you think you can have the best impact. And if enough communities did that, then we'd have the resources to participate in these. We're never going to be able to match the industry's effort, we know that, but we could do a better job than what we've done so far. And that's a comment not for all cities, because a lot of folks are really stepping up significantly, but if they had the benefit of everyone else pulling on that same rope, I think we'd have a better chance.
And the other thing I would add is that we can do a much better, two things actually. We can do a much better job of recognizing that we have partners. And I think very often, I think it can be hard for us to be working in coalition. Sometimes we actually find ourselves against public interest community members, organizations that could be partners. There could be other partners that we could be engaging. We should be thinking about that strategically, especially as we're looking at these sort of larger existential questions about ways in which we support localism, ways in which we support civic engagement in our work. And then the other thing I would say is that we need to do a much better job of doing basic education with elected officials on all of these fronts. Because I see in some cases in local government, there's one person who takes this on as their portfolio, right? And then everybody relies upon that one person, and then they move to another community or something ends up happening. And basically the brain trust leaves. And you see that happening in community after community. And I think that's a huge danger. So we need to be doing a much better sort of systematic job of explaining why these aren't. I mean, I know you're a lawyer. You're a lawyer. They are. She's a lawyer. I only play
He's
one.
A lawyer. He's a lawyer.
I only play one on TV. These are abstract, abstruse issues, but they should be things that the community leadership is fighting for. And we need to do a better job of that.
You know, I'd have to agree. Last year at the Conference of Mayors, there was a resolution put forth to remove the operational capital distinction, or, you know, for the mayors to encourage Congress to remove that distinction. And, you know, there was a moment in time where I thought that wasn't going to get passed. Luckily, last year, our mayors did pass that. So, I mean, so obviously we've gotten some elected officials up to speed on what they need to do. But continuing the questions.
Christine Wampler, Contra Costa County Television. For the MVPD proceeding, do we know when the decision's going to be made on that?
Maybe you can talk about that, Brian.
There's no shot clock.
We don't know. And there's significant differences amongst industry players on this. So it's not even clear what the pathway to having a ruling coming out is. So
It wouldn't be surprising if we saw it in 2015, but it could push over to 2016. I mean, I think we're talking about in the next several months, outside maybe 6 months. I guess I would be surprised if it pushed beyond that, but they don't have a clock on them. They can do it whenever they feel so inclined.
Yeah, I mean, and right now, industry is doing ex parte communications with the FCC on the rulemaking. It's your opportunity to do so as well. So I strongly encourage you to be able to do those ex parte communications. 2436.
Just so everybody knows, when we talk about ex parte communications, what we're saying is you can contact the FCC outside of the typical filing process, comments, reply comments. You just have to follow the procedure for those communications. But there was a template, I believe Steve Traylor was sending around a model template letter with talking points as it relates to the MVPD proceeding. And if you could just tailor that slightly to fit your own unique jurisdiction's issues and have your mayor execute that, send it out, or whatever your jurisdiction, you know, if it's a cable commission, what have you, I think Mike's point of the volume of comments received can have an impact, even when they've issued a tentative conclusion. But you know, I think Javan said, once they kind of reach a decision in their, what they call a tentative conclusion, has anybody actually seen them change a tentative conclusion? I haven't. So it's an uphill battle. You have to really push hard to get them to reconsider that.
Do we have any more questions? Okay, well, I want to thank you all for being here today, and thank you guys very much.